Hello everyone, welcome to Family Law Second Lectures, that is, a lecture on Muslim law. I'm Marjina Sultana, an assistant professor from Interpersonal Law College, Greater Noida. In this video, we will discuss Introduction to Muslim Law. Law may be either territorial or personal. A territorial law is that branch of a law which is applied in a particular territory, and it is applicable upon persons of all communities living in that territory. Thus, the Indian Penal Code or the Indian Contract Act are examples of territorial laws because the Indian Penal Code or the Indian Contract Act applies upon all the persons living in India. On the other hand, a personal law is that branch of civil law which applies upon the persons of a particular religious community. For example, Mohammedan law, Hindu law. The Mohammedan law applies upon the Muslims and the Hindu law applies upon the Hindus. What is Muslim law? According to Faizi, Muslim law in India means that portion of Islamic civil law which applied to Muslims as a personal law. So, in India, the term Muslim law applies to the personal matters concerning that section of the Indian society composed of people following Islam. Hence, the Muslim personal law governs the institutions of marriage, divorce, adoption, succession, and charity in the Indian Islamic community. The origin of Muslim law. The place of Muslim law's origin is Arabia, where Prophet Muhammad, peace and blessings be upon him and all the prophets, promulgated Islam. Arabia is the place where Islam was promulgated. Basically, it is of divine origin, that is to say, Muslim law originates from divinity. The Islamic legal system or the law of Islam is well known as Sharia in Islamic terminology. It is an Arabic word which literally which in literal sense means the way. Sharia refers to the matters of religion that Allah has legislated for humans. Since Sharia is originated from Allah, Muslims consider it as holy. Muslims considered Sharia as a word of God which regulate and evaluate human conduct. So Sharia consists of the injunctions of Quran, Sunnah, Ijma, and Qiyas. Quran is the revelation, we can say, it is the divine communication and the revelation to the Prophet of Islam. It is the first and the great legislative code of Islam. The second one, that is Sunnah, is the traditions introduced by the practice of the Prophet. Ijma is the common opinion of the jurist. And the Qiyas is the analogical deductions of the above three, that is Quran, Hadith, and Ijma. This is also further supplemented by the juristic preference called istihsan in Islamic terminology, public policy called istisla, precedence, taqleed, and independent interpretation called ijtihad. It has been further supplemented and modified by the state legislation and the modern judicial precedents of the High Courts and the Supreme Court of India and also of the Privy Council